This is Twit.
Obviously, yesterday was a very big day. Nilay and I were saying earlier that, seldom have we watched C-SPAN with such rapt attention. And there was quite a big hearing at the FCC yesterday on the issue of net neutrality, statements by all of the commissioners and the chairman, and now 200 pages of documents to digest and comment upon until September, when, in all likelihood, some iteration of the open internet rules that were proposed yesterday will be adopted. So I led off with Nilay by asking him what his highlight from the hearing was. Why don't I ask you the same?
Yeah, it's a hoax. You heard it more yesterday. You heard it from Eli today. Number one, there is no demonstrated problem here that can't be addressed through enforcement of existing laws, the antitrust laws and the consumer protection laws. Number two, the FCC is rushing into this when members on both sides, Democrats and Republicans, called on the agency not to rush. The agency should be doing a more careful job of actually thinking through, looking before it's leaping. And third, so there's the hoax that there's a problem here and that the FCC urgently has to act. And then there's the Title II hoax. So let me lay this out for you in as simple as I can. So the people who were literally jumping up and screaming yesterday during the meeting about Title II have no idea what Title II actually means. They think that Title II will end fast lanes, will prohibit prioritization on the internet. That is not true. All Title II means is that the FCC would have more power to regulate prioritization. So without Title II, they can regulate it, but they can't require that every broadband company provide exactly the same service to everybody. There has to be some room for what the DC Circuit called individualized negotiation. Whereas under Title II, the way that prioritization works and always has worked is you can prioritize, you can have fast lanes if you want to, but you have to go through what was called tariffing, where you file with the government the schedule of rates that you're going to charge to differently situated customers. So it's just not true that Title II is some radical difference that's going to allow the FCC to prohibit prioritization. Prioritization has always been part of the internet. It's the very thing that makes Google and Facebook and other services work. The question here has never been about net neutrality. The question has always been about whether broadband providers might be in a position to abuse market power in discriminating against certain providers. And as I said, the antitrust laws already deal with that. If you think that that's not enough, the FCC can deal with that through Section 706. So the real question becomes, does the FCC reclassify broadband, or I should say classify for the first time broadband as a Title II carrier? And the argument for that basically is the reasonable people will say, okay, we recognize that there are some problems with Title II. And so we're just going to forbear carefully, and we'll edit Title II down to basically a new framework for regulating broadband. That's what Janikowski proposed back in 2010 when the FCC tried to do this the first time. And if you remember anything that I had to tell you today, that is complete horseshit. That is not how reclassification or forbearance works. And the explanation is very simple. Forbearance is a difficult and cumbersome process. So the FCC has to justify why it's not applying certain rules and why it is applying others. And it would also have to justify not just going easy on broadband because we're concerned about broadband investment. It would also have to justify why it's not treating similar internet services the same way. Because legally, what we're talking about here is internet transmission services. And Google and other services, I don't want them to be more regulated. But as a legal matter, once you start going into Title II, the FCC then has to go through a very complicated series of legal contortions to explain either why some things, like broadband, should be under Title II and other things shouldn't, or why, if it's all going to be under Title II, why the FCC is going to forbear from some things, from some provisions of Title II and not from others. So the bottom line is that in order to get a relatively small difference of how far the FCC can go in regulating discrimination, the FCC would have to completely change the presumption of regulation that was put in place not by the Bush administration, but by Bill Clinton's FCC. And it was that decision to put broadband under Title I that unleashed $1.2 trillion of private investment that built today's broadband networks. So that's what we're talking about here today. And that's why I say this is a hoax. And the FCC, because of this political hoax, because people have been conned into thinking that Title II means something other than it does and that it would be easy to apply, the FCC is now going through this farce where they have to pretend that Title II is a realistic option and that they're considering it before doing what every serious person knows they're going to do in the end anyway, which is to try to regulate through Section 706.
Right. And do you think that they'll still have problems if we take everything you just said as a given under 706? Do you think once again the D.C. Circuit or another court will come in and say, once again, FCC, you've gone too far here?
Well, there's two different potential risks. There's three issues with 706. Number one is the fight here is really about the outer boundary on 706, which is they can't impose common carriage. And common carriage, as I was saying about Title II, would mean saying something like, okay, if you're going to prioritize, you have to charge exactly the same price to all similarly situated services. That would be a common carriage requirement. And the FCC probably can't do that through 706. Now, they can do things like saying, if you favor an affiliate or you in some other fashion discriminate, that could be a violation under 706. So that's one legal issue. Second issue down the road is, and frankly, this is true whether they use 706 here or not, and it's true whether they reclassify or not. 706 allows the FCC, as they have interpreted it, to regulate not just broadband, but the entire internet, in fact, all communications, which is very disturbing. And that brings me to the third point, which is, I have to say, while I think that it's possible for the FCC to craft a relatively reasonable rule through 706, I also think that the FCC and the D.C. Circuit got it wrong, that 706 simply is not an independent grant of authority. And without unpacking that fully, I'll just say that the only reason that we're even there is because courts in general defer to agencies when a statute is ambiguous. And I think the legal error that the D.C. Circuit made was in determining that either that this statute is ambiguous or that the FCC's interpretation of it was reasonable. So it's possible that the courts will ultimately strike down anything the FCC does under 706. It's possible they'll reverse this interpretation. And I think that would, on the whole, be a good thing for the internet. It's probably not very likely, but this is my way of saying that the FCC really has no good options, legally speaking. What they really should be doing, what I would do if I were the chairman, is to say to Congress, 706 is shaky and Title II is not a workable option. And rather than continue to try to do this for the third time and spend another 3 or 4 years going down a road that's probably going to lead to nowhere, the FCC, call on Congress to do what everybody across the political spectrum knows needs to be done, which is to update the Communications Act. Because the fundamental problem is that these titles, Title I, Title II, they don't correspond to the real world anymore. So there is, I think, a need for a new Communications Act. And this is not crazy. Verizon and Google in 2010 agreed on a joint legislative framework for a new Communications Act that would have solved this problem of how the FCC should regulate net neutrality. And in 2005, you had a broad bipartisan group of telecom experts that proposed what was called the Digital Age Communications Act to fix this general problem, rewrite the act, and give the FCC a sensible way of regulating broadband and the internet generally without subjecting Google and Facebook and all the other companies that the FCC claims to be trying to protect here to the kind of regulatory burdens that the FCC might be able to impose through 706 and might be forced to subject to Title II in court, even if they don't want to. So anyway, I just want this to be ultimately left up to the democratic decision-making process. It's a policy question, and it's not one that the FCC really has the tools or the competence to be trying to solve.
But the people are speaking, right? I mean, they might be conned. You might think they're low information voters in a sense, right? They're speaking. They're saying they desperately want broadband to be regulated as a utility, as a common carrier. And whether or not you agree with what they're saying, the substance of what they're saying, they're definitely saying it. They're saying it more loudly and more vigorously about telecom policy than just about anything else. It's actually remarkable. So,
yeah, well, you know, Nilay, the last time I checked, we don't live in a mobocracy. We have elected representatives who are sent to Congress who are supposed to make decisions.
But they're
so
saying
when
it
I say
too.
Democratic, no, listen to me. No, people don't get to scream and bang. No. Congress ultimately can make this decision.
Are you
and
saying
they should.
that the people of the United States of America, instead of speaking however they wish to speak, they should quietly petition their elected representatives who then make a decision in their best interests? That sounds crazy to me.
So this is hilarious because you're trying to embrace democratic legitimacy, but what you're really saying is you want 3 unelected bureaucrats at the FCC to decide what they think the people want.
To use authority that they already
instead of
have.
having our elected representatives decide what is actually going to be the law.
That docket is open. The path is clear, right? You can walk right through that door, and you and I can argue about the substance of Title II, but the demand from the public for the FCC to more legitimately consider that is clearly there. And there's no reason of process.
It's based on misrepresentation
how is it manufactured?
Like you of what this issue is about.
Wait, how am I manufacturing this issue?
What exactly is the harm here? The FCC has alleged 4 instances over 15 years of supposed net neutrality violations, 2 of which wouldn't even be dealt with by their proposed rules. This is a hoax. The FCC has never demonstrated that there's a
I can tell you the harms very clearly.
You have also misrepresented it, as has everybody else, what Title II actually means and whether the FCC can actually apply it in any sensible way.
Look,
Title II has never been a politically realistic option. And even the Democrats on the commission who have pushed for the FCC to ask about Title II, I don't think are serious about actually using it.
So what your argument boils down to is you don't believe the Democrats are serious about the option they're proposing. That's silly. What you're actually saying is the harms aren't there and we should wait for the harms to accrue before we do anything about them. And I'm saying I've been covering this industry. I've been covering this industry deeply for years, ever since broadband became the force for change in this country. And I'm telling you, I see the harms at every turn because these companies are not in a competitive market, and they do not have incentives to act in a rational way that serves the interest of the consumer.
So I'm telling you, as a telecom lawyer, which you are not, that Title II, A, doesn't do what you think it does, and B, cannot be applied effectively because forbearance is not a realistic option.
Let me ask you a question. So why did the FCC originally try to apply Title II with forbearance?
To get government out of the way of broadband deployment. I would point out to you that while you and others talk about cable being a monopoly, in fact, cable is losing ground to telco providers today who have turned DSL into what was once a joke and a slow option into something that at speeds of like 45 megabits per second is actually faster than cable. So A, there in fact is competition coming from telephone companies.
Who is my competition? I live in New York City. I live in New York City and I have Time Warner Cable. Who am I going to because that service sucks?
So in fact, so AT&T by the end of 2015 has said that they will deploy 45 megabit per second service.
I'm waiting a year. I'm waiting actually a year and a half for AT&T's promised infrastructure deployment. That's her competition.
So let's, for example, look at Verizon. Why do you think it was that Verizon didn't deploy in major cities like Baltimore and Boston? It wasn't because they didn't want to. It was because those cities made it prohibitively difficult to deploy new infrastructure, which is precisely the same experience that Google Fiber has had. They have tried to deploy, and they found that local governments have made that unnecessarily difficult. So I'm all in favor of more broadband competition. We could actually be having that discussion, and that would be productive. Instead, we keep running around and around pretending that the FCC can solve a problem that hasn't been demonstrated.
Let me ask you a question, though.
Nilay, I need to jump in for just a second here. I want to just interject that as I listen to you both, I'm coming to the opinion that perhaps you're both right, and that it's always been my inclination looking at this issue that we're only having this conversation because of the confusion, the legislative confusion about what fits into Title I and what fits into Title II, and the internet not fitting properly into either, and that Congress really needs to fix that. And the way we fix that is amending the Telecommunications Act. But Nilay and I were talking about this at the top of the show, Berin, that, until that can happen, that might be a slow process. Hasn't happened yet. Congress certainly doesn't seem to be in a rush, even though, as we sit here today, the urgent need for that has never been more clear, that the FCC does have some room to work here, and that they may as well give it a shot. And that, I understand, Berin, that your position is giving it a shot is going to mess things up more than help. But if the FCC agrees, disagrees, there's no reason why they can't, continue down this road and then let Congress correct them.